Viewers and welcome to HSA Simplified video series. I am Jivesh Chandrayan, partner at the firm's New Delhi office. Today I'll talk about a topic of great importance to both companies and their employees. That is, the enforceability of restrictive covenants in employment contracts, which are meant to keep employees contractually bound even post-termination. Broadly speaking, employment contracts contain either positive covenants, that is, obligation to do something that restricts the employee, or direct restrictive covenants, that is, obligation not to do something. Few examples of such restrictive covenants are non-disclosure, non-compete, non-solicit, or garden leave clauses. We are all aware of the fact that inserting such restrictive covenants has become commonplace in employment contracts, put in place by enterprises for the ever-increasing need for protecting trade secrets and business know-how. However, it is important to understand whether such conditions are valid and enforceable under the law. While Article 19(1)(g) of the Constitution and Section 27 of the Contract Act form the basis of the statutory law on the subject, upholding the employee's rights. However, India being a common law country, the legal position of such covenants can only be determined by a harmonious reading along with the extant judicial precedents. Thus, there cannot be a straitjacket formula to determine the validity of restrictive covenants. Considering the ever-increasing need to protect enterprise value, especially in the IP-driven economy, and foreign investments, the higher judiciary in India has cleared the air to a large extent by making an attempt to balance ease of doing business with employee rights. Under the prevailing trend in judicial precedents, it has been held that restrictive covenants are not in restraint of trade unless the terms of such restraints are unreasonable, unconscionable, excessively harsh, or one-sided. While all agreements in restraint of trade could be prima facie void but would be binding upon the proof that the restriction is justifiable in the circumstances as being reasonable from the point of view of the parties themselves. With that being said, it is important to understand that the applicability of law on restrictive covenants will vary from case to case, reasonability being the test of enforceability. So here are a few practical tips for stakeholders while implementing restrictive covenants. First, restrictive covenants should be territorially limited or should be for a reasonable duration. Second, employees may be given monetary benefits during the restraint period. Third, mentioning liquidated damages in employment agreements could be a valuable deterrent preventing breach of restrictive covenants. Fourth, the employer must urge the employee to maintain independent legal advice regarding implication of restrictive covenants and can also give the employee a list of competing businesses. Finally, but perhaps most importantly, the employer must not use a boilerplate one-sided take it or leave it agreement for every class of employee. I sincerely hope you enjoyed the video. Feel free to comment in case you have any views. Cheers.